Should the law treat people differently based on race? A controversial Supreme Court ruling instructs judges now to use a different type of analysis when sentencing Aboriginal offenders. Now, some are calling for the federal government to put an end to this. Let's go live now to Winnipeg to bring in Winnipeg Sun columnist Tom Brodbeck. Now, Tom, you're calling this law or ruling racist. Why do you feel that way?
Well, it absolutely is racist. It calls on the courts to treat a group of people differently based on their race, based on their ancestry. It demands that the courts, in every instance where there's an Aboriginal offender before them, to use a different type of analysis to arrive at a fit sentence based solely on their race and their ancestry, whether the background and the historical wrongdoings that we all know about have any effect or had any impact on, or is it even relevant to any particular offender. So that is racism. When you say that someone should be treated differently, discriminated against based on their race, that's racism, and to me it violates the Charter of Rights.
Now, Tom, give us the background on this. What was the justification for a ruling? Because it seems to me that by giving lighter sentences to someone just because they're Aboriginal is discounting the seriousness of the crime. A crime is still a crime.
Oh, absolutely. I mean, and this goes back to 1996, and a lot of people may not know this, but we're talking about a one-sentence change to the criminal code going back to 96 that the then Liberal Justice Minister Alan Rock brought in. They made a number of changes to the sentencing principles in the criminal code, and one of the things they talked about was where appropriate that the court should try to find sanctions that are non-jail terms. And then it says, and it's literally 9 words, and then it says, comma, and special attention should be given to the circumstances of Aboriginal people. That's all it says. That's all the criminal code says with respect to this issue. The courts have taken that and they've turned it into a monster. They've turned it into something that, you know, it was a very ambiguous, very generally written sentence into pages and pages of court rulings, and we now have this hard and fast rule that if you're an Aboriginal offender, you should be treated differently. There should be, the background, the historical wrongdoings that have occurred in Canada should be a mitigating factor in every single case where there's an Aboriginal offender.
And Tom, just give us a sense of what are we actually seeing in the courts? I know there was a recent case in Winnipeg. What kinds of sentences are judges actually handing out, and how lenient are they when it comes to Aboriginal offenders?
Well, it really depends on the case. Obviously, the more serious the case, the more violent the case, the less this is going to come into play. The judges are going to give less weight to it. But they still have to consider it. They still have to give some weight to this principle. The lesser cases of assault and, robbery and those kinds of cases, it's going to play a factor, and it has. And this isn't the first Supreme Court of Canada ruling on this. We go back to 1999, the Gladue ruling, which is the big one, and it's called the Gladue report, and the latest ruling out of the Supreme Court reaffirmed that ruling, but also took it a step further and said, you know what, the courts aren't really taking Gladue seriously. We really mean that every single time an Aboriginal offender comes before the courts, that this sentencing principle, that they're treated differently based on their ancestry and their race, must come into effect. We weren't kidding, basically, is what they were saying back in 1999 when we made this ruling. So they've not only reaffirmed it, they've taken it a little bit of a step further. They've clarified certain aspects of it. For instance, they said, some courts have decided that the more serious cases, the violent cases, this shouldn't apply. The Supreme Court of Canada, in its latest ruling, said no, it applies in every case. You'll give different weights to it depending on the circumstances of the case, but we're clarifying that it has to come into play into every case where the offender is Aboriginal.
And so, Tom, very quickly, I know you are calling on the Justice Minister to take action. What do you want to see done?
Well, that's the next step here. I mean, again, you're going back to a 9-word line in the criminal code that's turned into something that the courts have turned it into, a judge-made law. I think the federal government now has to take a serious look at this provision in the criminal code and decide what to do with it. I think they should get rid of it. I think every Canadian should be equal before the law and before the courts, and their ethnic background, their ancestry should have nothing to do with it.
Absolutely. Well, we thank you, Tom, for weighing in on this today.
Thank you.